welcome back to the CPP Disability channel. My name is Robyn and I'm the videographer here at Resolute Legal. And today I am joined by Katie Conrad, one of our disability lawyers. And today we're going to be talking about how to write a hearing brief. These are things you have to write for the law, for things, and Katie's going to tell us all about it. So how about let's start with Katie, what is a hearing brief?
So a hearing brief is a written document that you would prepare when you're going to the Social Security Tribunal for a hearing on your CPP disability appeal. And basically it's a long document, fairly long, that sets out the important facts of your case and the key arguments for why your benefit should be approved. So the ones that we write typically are in the range of 12 to 15 pages. Someone at home doing their own, it might not be quite that long. It probably doesn't have to be, but ours are typically quite comprehensive.
Is it the same thing as a cover letter, or is it different?
So this would be different from a cover letter. So a cover letter would be a lot shorter and would be sort of more of an overview in a narrative form of your story typically. Whereas in a hearing brief, you still want to be telling a story and having a narrative, but it's much more formal. It's usually done in sections. There's a fact section and an argument section, and it's quite formal, and you're really going through the facts of exactly what your doctors have said and what your legal arguments are. Whereas, in the cover letter, you're just sort of telling your story and trying to get them on your side. Basically, there's two main sections. So one is the facts, and that's going to include a number of different things. So for example, the dates relating to your CPP application. So when did you apply? When did you do your first appeal? And so on. There's going to be dates related to your work situation. So when you stopped working, obviously, is an important one, but anything, if you had workplace accommodations, when did those start? If you changed jobs or went back to school or anything like that because of your disability, you want to make sure those facts are in there. And then, of course, the medical facts are going to be a big one. Now, you're not going to list every doctor's appointment that you've ever been to or anything, but you want to get sort of the key medical facts in there. So any important statements from your doctors about, if they said you can't work, anything they've said about why you can't work is very important, as well as any key information about treatments you've had is going to be important to include there. So those are the main things to include in the facts section. And then in the arguments, this is your sort of legal argument for why your claim should be approved. So again, someone doing this on their own at home, maybe you don't know all of the legal rules and everything, and that's fine. The main things you want to focus on are, come back to that definition of disability, that it's severe and prolonged. You want to make sure you cover your arguments for those 2 points. So, as far as whether your disability is severe, again, you're going to be wanting to make your arguments about why you can't work, be clear about how your conditions cause limitations, how do they prevent you from working? What is it that makes it so that you can't go to work? And again, anything you've done to try to stay at the workforce in terms of modified duties, lower hours, changing jobs, going back to school, anything like that you've done, you want to make sure that's in there to show that you have tried your best and that you couldn't do it. And then another important thing to include in your arguments, again, is about treatment. That's one of the main things they're looking for, is that you've made all reasonable efforts to participate in treatment. So you want to make sure they know everything that you've done and that you've followed your doctor's treatment recommendations. And then on the prolonged aspect, treatment plays into that somewhat, because if you've done all the treatments and haven't get better, chances are you're not going to get better in the future. And then, of course, anything from your doctor saying that it's likely to be prolonged or that you're not going to get better in the foreseeable future want to be included in there as well. Yeah, those are the sort of key things to include in your arguments.
How about you walk me through the process of how you actually write a hearing brief?
Sure. So the first thing to do is we get all the documents in order and go through them and create a timeline. So at the point where you're writing a hearing brief, you've probably submitted all your documents to the tribunal already and gotten them back as the hearing file where they put like the little page numbers in the corner and everything. So you want to work from that copy so that you have the same page numbers that the person making the decision is going to have. That's also a good way to make sure you have submitted everything and double check that you haven't missed any documents. So we start from that file and create a timeline. You want to make sure you've got everything in order of when they happen. So we have, a special program that we use for that. But, again, someone at home, if you use a spreadsheet or a Word document or, write it on sticky notes and put them in order on your wall, whatever works for you. Just so that you have it straight of what happened in what order. And then once we have that, that makes it super easy to write the facts section of your hearing brief. So, you go through, and again, you're not going to list every single little thing. And that's not what the tribunal wants. They actually have done training sessions on how to send your submissions, and they don't want to have a huge fact section that goes through every detail. They want to see the absolute key things. So again, the important statements from your doctor, the important things about any job changes, and important treatments. Those are going to be the main things you want to focus on. You're not going to quote an entire doctor's report. You just want to quote the main statements that they've said. So when we're writing them, we do the facts just as bullet points and go through them so that we get everything important set out for them. And then once you've gone through your facts, that often makes it easier to do your arguments because you have it in your head very clearly, what the story is, what's happened, what the key statements from your doctors are. And then it's just a matter of sort of putting those points into, paragraphs of, how does that show your disability is severe? How does that show that your disability is prolonged? So you can set that part out in your arguments once you know what all your facts are.
Are there any standards or rules that you're supposed to follow when you're writing a hearing brief?
So there's not rules per se. As long as it's sort of sets out the points of your case, that's really all you have to do. That said, as I mentioned, we have gone to these sort of training sessions that the tribunal actually puts on. They don't want huge, big quotes. They don't want, every detail put into the facts. Keep it concise and try to use, clear, plain language as best as you can. If you are citing legal cases or specific parts of the legislation, if you do get into any of that in your brief, make sure they know what it is that you're quoting from. They know which cases you're referring to, or which, if you're using the wording from the Canada Pension Plan, make sure they know what you're referring to. So just be clear about that. Outside of that, try to make it just easy to read. When we do them, we use lots of headings, lots of white space, bullet points or numbered lists wherever possible, just to make everything easy to read, make it flow easily, just make it easy for the person who's making that decision to read it, understand what you're saying, and don't make it harder for them than you have to. As far as other things I could say, you should have an introduction and a conclusion before your facts and argument. Those don't have to be long, and it's not, going to be pages and pages for an introduction, but, start out with a few paragraphs to give them a bit of an overview about your story and your history and your condition before you jump into the main facts section. And then in the conclusion, you're basically just going to summarize what you said, and you should always end by basically saying what you want, that you are claiming for your CPP benefits to be approved and ask that they do so. again, they're going to know that's what you want because you're there at the appeal, but it's good just to make that totally clear at the end what it is that you're actually looking for. Yeah, in your facts section, another thing you can do, again, just to help the decision maker, make it easy for them to follow along, is, if you're quoting from a specific doctor's report, as I mentioned, you'll have that hearing file with the page numbers they put on it. If you're quoting from a doctor's report, tell them what page that report is at so that they can easily go find it and look at it as they're going through. If they say, oh, what else did that doctor say? And they want to refer to it. Again, just something to make it easier for them so that they don't have to work as hard to get them on your side.
So it is different than the cover letter, because we hear about clients all the time asking what to put in their cover letter, but I'm hearing a lot of similarities between the two things.
Yeah, they're similar for sure, in that, both are documents that you're writing to try and get someone on your side, and, you're trying to be persuasive and make your arguments and tell your story, basically. The main difference is that the hearing brief is going to be more detailed and longer, and there's sort of that more clear separation of here are the main facts I'm relying on, and here are my arguments. Whereas in the cover letter, it tends to be more the story as one sort of flowing thing.
So that's it. Thank you guys for joining us in this video. We learned all about a hearing brief, which you write out, and it summarizes your entire claim for the adjudicator to review before the Social Security Tribunal. My name is Robyn, and this is Katie, and we will see you later. See you in our next video.